Words are not enough, yeah.
Enough to say thank you.
So Lord, you are my everything.
You're my everything.
How can I express my gratitude?
How can I express my gratitude
For all the many things,
for all the many things you
Father, you done for me, yeah.
Words are not enough to say thank you.
So Lord, you are,
Lord,
you
you're
are.
my everything.
See, I call you
call you
Jireh.
You're my provider.
I call you Nisi. You are my battle. I call you Rapha. Hey.
You are my healer.
Say, Lord, you are.
Lord, you're my everything.
I call you Jireh.
Call you Jireh. Lord, my provider.
I call you Nisi. You are my banner. I call you Rapha.
You are my healer.
Say, Lord, you are. You are.
Hello, good afternoon to you once again. It's another opportunity for us to meet again on the program The Community and the Law. It's brought to you by BWF Solicitors right on BWTV and on all the social media platforms, Facebook, YouTube, LinkedIn, and your networks where you always find yourselves. We are going to this afternoon look at something you need to know, something you need to have, some experience you need to really develop, and also to make sure that you run your business the right way. How to run a successful home office approved sponsorship license as a business. Now, there are traps and pitfalls you need to avoid, and this is the direction we're going to go this afternoon on the program. It's the Community and the Law, and as I said, brought to you by BWF Solicitors. Let's get into it together.
Welcome to BWF Solicitors, a trusted and experienced family law firm specializing in immigration and naturalization, as well as dispute resolution. Meet Bernard Owusu, our esteemed senior partner with over 30 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stand for integrity, respect, excellence, teamwork, diversity and inclusion, and service to the community. We provide tailored assistance across all areas of UK and Ghana law. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Led by experienced senior partner Bernard Owusu, the team at BWF Solicitors is ready to assist you with your immigration, naturalization, dispute resolution, family law, new wills and probate, Ghana law and practice needs. We are dedicated to providing solutions to our clients' problems. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Main office line 0208 493 7340 or our emergency line 07712 761 884. Our private client services team is recognized for providing clear and practical legal advice to our clients in the United Kingdom and Ghana. Expert help with will writing, probate or estate administration. Our will writers and probate lawyers can act for you to obtain grant of probate and carry out estate administration on your behalf. The probate takes place after someone dies. If there's a will, the named executor is responsible for ensuring that the estate of the deceased is secured, assessing its value and paying any inheritance tax. If there is no will, the interstate and inheritance rules require similar responsibilities. Our lawyers offer strategic and practical solutions to the issues which clients face, whether it's in relation to succession planning, will preparation, probate and the administration of estates, immigration and visas, contentious family or probate disputes, administering estates often with inheritance cross-border issues, international trust advice including residence, domicile issues, wealth preservation, a fast, efficient service from SRA-regulated professionals, transparent pricing. BWF Solicitors, let us take care of probate.
Welcome. And once again, I want to express my appreciation for your time and your loyalty and, of course, commitment to the community and the law. We are here this afternoon, as I mentioned earlier on, by courtesy of BWF Solicitors, our trusted partners when it comes to the law. Located on the fourth floor of the Ghana House, 214 to 218, Tottenham High Road, Seven Sisters, North London. They operate between Monday and Friday, 9:30 in the morning and 6 p.m. in the evening. Weekends, you can get them by appointments only. And when Thursdays, Fridays, and Saturdays, they also come and do an outreach program in the community to educate the community as to what the laws are and what it is that you need to have and do when it is that you contemplating on your immigration status, nationality issues, family issues, talking about your property here in the UK and even back home in Ghana, wherever outside of the UK. BWF Solicitors is the trusted source for all the support you need legally. And we have said thank you to them, and we're going to invite them to help us in our discussion this afternoon. A couple of weeks back, I brought in two wonderful personalities in the community, directors of one organization that successfully runs a care agency and domiciliary care organization. They have successfully applied for certificate of sponsorship and they are doing things right. So we learned from their experience. Now we're following up this afternoon on this because once you know what the good practices are, how can you avoid the traps and pitfalls so that you will not fall foul of the law and the Home Office will continue to grant you that permission to bring in workers from outside of the UK to help you in your business. So the question is, how are you going to run a successful Home Office approved sponsorship license as a business? And of course, as I said, the traps and the pitfalls you need to avoid. So we're going to look at that this afternoon. And I have the main man himself because he is so well versed in what the laws are, the strategies, and the things you need to do. So I have the main man from BWF Solicitors here with me this afternoon to help us look at that. And talking about no other person than Mr. Bernard Owusu, the senior partner of BWF Solicitors. Uncle Ben, good afternoon.
Good afternoon, Kweku.
Thank you very much
How
for
are
your
you?
time. Yeah, I'm good. I'm good.
Good,
So
good,
by the
good.
grace of God, we are good. As I mentioned, we're looking at best practices. So obviously, with you knowing what it is that there is to do, uh, we know definitely you will share that experience with us again today afternoon.
Yes, so good evening or good afternoon to everyone who is watching us. It's my absolute pleasure to be here with you today. There's nothing better than serving your community and having done that, for 3 decades and going strong and strong and strong. I think normally when things happen in the community, we as a firm of solicitors um, prefer to discuss it in open forum so that we hear from other people and share knowledge and experiences and see what is the best practice in the community. So as you can see over the last few weeks, I'll say about a month or more, and it's even going to be more going forward because we've got videos out this week and next week. And then next Friday, I've been invited by the Ghanaian Union to also share my knowledge in this area. As a particular area of law, which is really doing very well for the community. People who are traveling to the UK legally, and not only traveling, but traveling to the UK because there is ready-made work for them. And, once they comply with the law, this will lead to settlement. So skilled worker route, particularly for people in the adult social care, adult social and health care, it's a big thing. It's a big thing that we want to make sure that both the businesses survive and also those who are coming here are aware of their rights so that we all work together and sync and ensure that the community benefits. Because if individuals come together as a community and we work towards one goal, which is that we support each other, we support each other's businesses, we don't undermine businesses, we support those who are coming here, we don't abuse their trust, we don't just take their money and run away, but then we provide them with the services that they say that they need, and we said we'll provide them. Then it works very well for the community. So today our focus is on compliance. A couple of weeks ago, my own younger brother and his wife, Sebastian and Rhoda from St. George's Group, they came to share with us the business
right, yeah.
development. What people don't realize is that almost all of these businesses have been running for a minimum of 5 to 10 years.
Okay.
So before this sponsorship scheme started, they were already running successful businesses.
Okay.
And this is like a bonus for them. But also, what I always say to people, we all have our particular skills and talents that God has given us. And if somebody is skewed towards a care work, there are particular talents in there. There's the other part which makes their business complete, especially if they've got a sponsorship license, and which is a compliance and the law. And that is what we're going to talk about today.
Yeah, so you have had a good gist of what we're going to talk about. Even the summary and introduction gives you a lot of detail, so you don't have to miss the real discussion for all the good in the world. And before we go on, before we come on the program on a Saturday afternoon, BWF Solicitors helps us to enrich our knowledge and some of the things that happen and the updates that come from either the Home Office or in the total area of law, they bring us that. And this afternoon, we're looking at students and student dependents who can have their NRPF, that is no recourse to public funds, removed. What is that? I'll be reading the text as you see on the screen, and I'll ask our senior partner to help us unpick that and see how we can go about that. This is based on a case R on the application of PA and another. This is the Secretary of State for the Home Department, a 2023 case. And it says that the SSHD, that is Secretary of State for Home Department, has discretion to remove the non-recourse to public fund condition for students and their dependents. Failure to lift may amount to unlawful conduct under public law. The 1971 Immigration Act provides the Secretary of State with the power to exercise discretion in considering whether to vary the conditions of any leave granted, including the lifting of the no recourse to public funds from permission granted on all immigration routes. The SSHD has now issued an operational policy instruction, that is OPI, to this effect. It might sound self-explanatory, but there are certain caveats in there that I would want us to unpick. If you look at the second paragraph, the 1971 Immigration Act provides the Secretary of State with the power to exercise discretion. So does it mean that it is not a given that whatever it is, it will be taken off? If the discretion is being carried out, what are the conditions? How does anyone satisfy any criteria or whatever it is? We would have to have that. So with Uncle Ben around, I think we're so privileged that he knows it inside and out. And I can tell you that some of these things, when they come out and policy changes, guideline changes, when they do come, he plays a pivotal role in that. Why am I saying that? Because he researches, he tells them that this does not work for the community, this does work for the community. Let's do it this way or that way. So Uncle Ben, let me come back to you. Let's delve into your wealth of experience. What is the Home Secretary talking about here?
Okay, so first of all, this lady, and it's a Ghanaian lady, she's our client.
Okay.
Okay. Yesterday, she actually sent me a text and said, Uncle Ben, I'm very grateful to you that through me, you're also sharing this to help other people in the community.
That's right, yeah.
But we didn't do this work. This work was done by a charity. And I'll explain why these things do happen. We run a private business. We're not supported by the government. We don't do legal aid. And some of this work are very, very expensive. So you engage baristas, you prepare bundles, you do research. By the time you finish, a potential case like this will cost you about 25,000.
Oh.
If we are charging her, we will charge her about 5,000 plus disbursement. Potentially, she's looking about 10,000. Somebody who's going for no recourse to be lifted, she hasn't got that money. So it means we don't get to do these cases. But if you read the case very carefully, the judge referred to something called Section 3C leave, which is what she had. We got that for her. My daughter Deborah is the one who was working on her case.
Okay.
And then because it's anonymized, we will not mention her name.
All right.
I'm sure she will talk to other people, they will know who she is. But we have a duty to protect her identity. And normally, when you see abbreviated names, it means the case is anonymized, potentially because of health reasons or because of a child. In this case, she had a child. And she's come to this office regularly. The last time I saw her was, a few weeks ago.
Okay.
But the last time I chatted with her was yesterday. So she's our client. But she went to this charity to support her. She came here as a student dependent. And when she came, if you're a student, one of the requirements is that you will be able to support and maintain yourself without recourse to public funds. So it's a mandatory requirement or it's an eligibility requirement. So to now go to the Secretary of State and say, remove this,
Remove that thing.
then it becomes a problem. But it's a test case. It's a test case because it's never happened. And what's happened is that there's within the Immigration and Nationality Act of 1999,
Right.
Section 115, it talks about, this area of law about no recourse to public funds, what public funds are. But the Secretary of State under Section 3, small c and 1, because 3c, Section 3 big C is a different category. That's what she was on. But the Secretary of State has power under Section 3 small c1 to also add or subtract conditions from your leave.
Okay.
And it was that contention that went to court. And before the matter went for adjudication, the Secretary of State conceded, oh yes, I have made a mistake. I think because I have the job to add or subtract, I also have the job to allow no condition or add no condition. And that is why this case is very important. It's the biggest case so far this year because the test in there is the policy, the operational policy instruction, the OPI that has now been drafted. And when you look at it, the Secretary of State says that any migrant at all, any. So there's no exceptions now. Any migrant at all can apply for the no recourse to public funds to be removed. Bear in mind that almost all temporary migrants have a mandatory requirement to accommodate and maintain themselves without recourse. But if you're given recourse, remember that 3-4 months ago, the Secretary of State said, even for spouses and parents who are on the 5-year route, if you apply for no recourse to be lifted and it's lifted, we will remove you from that 5-year, we'll still put you on the 5. So it was something that it was in the pipeline, but it took our very strong and young lady, she is in her 30s, it took her to push the Secretary of State to accept that, anybody at all who is facing challenges, which will be 4 areas. 1 is destitution, 2 is potential destitution, 3 is a child's needs because you can't work, and 4 is sickness. So if you have any of these situations, you don't have to suffer in silence. If you go to the Secretary of State, he will lift the no recourse. And if you claim, it will not be a deterrent to you progressing onto your second 2.5 or even onto indefinite leave to remain.
Well, let me ask a question then. When I was reading that, I picked out the exercising of discretion. You've given us 4 conditions. If I do qualify or satisfy those 4 conditions, would it be automatic for the Secretary of State to remove the no recourse to public funds, or there may be other considerations?
Yes. So where we talk about discretion, it means that the Secretary of State may remove or may not. And as with every area of law which is discretionary, it is subject to the court's jurisdiction through judicial review. So although it's a discretion, the Secretary of State is also aware that if she doesn't exercise the discretion properly or reasonably, then she can be challenged in court. It's a discretion under Section 3 of the 71 Act, but it's a discretion that is always exercised carefully. And you can see that in this case, when the Secretary of State said I wasn't going to lift it, she went to court and she succeeded. And yesterday, her lawyers wrote to us. There's another aspect of her case that I don't want to go into. They wrote to us, and we're working with them, and we'll see whether that part she's going to be successful. Hopefully, if she's successful, then it's going to help the community. But she is a very, very nice lady. Maybe one day we'll bring her onto the program for her to tell us what really exercise her mind to go this far and challenge whatever is being century-old condition in this country.
I can confidently probably say that over the years, the encouragement you've given to the community, members of the community, to be confident about knowing some of these things, challenging some of these status quos and the rest of it, has pushed this woman to really do what she has done.
Well, Kweku, as I've always told people, I started this journey in my mid-20s. I was very fortunate to meet some of the most renowned lawyers in the community, and they were all barristers. And those people who took me on to work with them, up to today, those who are still alive, I'm still on good terms with them. And when they travel to this country, they look for me. The former Treasury Secretary, mother, Ms. Charlotte Boyte, as somebody who mentored me. She speaks to me regularly. She has enormous respect for me. She refers cases to me. And for me, what I learned from her was to serve the community. She served the community every Saturday continuously for 40 years. I've done that for 31 years. So I've got 9 years to go. What really drives me is all the things that people get satisfaction from when they help other people. Be it training people to qualify as lawyers, people who may not have had the opportunity from anyone else because they are either old or maybe their standard of education is not at the level that the city firms were looking for. Or maybe other firms didn't have the money to pay them, and I took all of them and I trained them. But beyond that, what I also do, which gives me a lot of satisfaction, is the things that I do on a daily basis, which is providing information free of charge to people. And through that, in 2020, I was recognized as the senior most professional in our community, the whole of United Kingdom, by the British Black Business Awards. And for that, that's for me, it's a blessing that I always say I thank God for. So those are the things that drive me. The other things that come with it is we run a business. So you have to pay your staff.
Yes, that's
So, you have to earn some money and pay them and make sure people are able to go to law school. And when they come and you train them, you also have to send, once they've trained, you have to pay for them to go to another law school again
Right.
for, I think, about 3 or 4 months
Okay.
for them to get a final certification, and then you sign it for them. So I'm a driven man. I'm very, very driven, not for money. No, it's never been about money. God bless us with money. Silver and gold, God says is mine. So when you do your things properly, the money follows. And I thank God because I have never lacked since I started this work. And even now, as I tell people, I don't lack. God has looked after me and my family very, very well. What we pray for is longevity, good health. But I will keep doing what I do, which is to help the community through training those who need to be trained and also providing information and education to the community, and where we can also provide free service to the community.
Well, people shouldn't be surprised if one day they will see me as a lawyer. I will be wearing
Yeah.
the whole thing. And with that, I want to say congratulations to many of our compatriots in Ghana who were called to the bar earlier this week. And I want to say congratulations from BWF Solicitors, BWTV, and from all of us to all of you. Congratulations, and keep burning the flame so well, so that we can help our communities wherever we find ourselves. And before we go into the discussion, there's another thing that dropped yesterday, and it is something you graciously put in the community, and it is the government impact assessment on immigration health surcharge, and the recommendation that they increase the levy from £624 per year to a whopping £1,035 per year per applicant, which is 2,587.50 for 2.5 years, starting from January 16, 2024. What's happening here?
Well, so, this has been, it's expected, really. So we've been looking forward to this for some months now. And what's happening is that the government said through the Prime Minister that they wanted to recoup some money and they want to recoup money through migrants because they wanted to pay doctors more, nurses more, and they didn't want to increase their budget or borrow money. So they said, well, the easy target, and as we call them in business, or the low-hanging fruits, are the migrants because they work and pay taxes, but yet they have to pay to use the NHS. And that immigration health surcharge is a levy which is put on migrants who are here temporarily, from people who are coming here for more than 6 months to parents and families and children, husbands and wives and partners, grandmothers and stuff like that. It's very, very costly venture. What they've done is, as with every area of law where there's going to be significant change, they do what we call government impact assessment. It's done by the Home Office, and the Home Office recruits consultants to take some surveys and data to analyze the data. They've done the analysis, but that's not what we're going to discuss here. What they've realized is that if they increase it by this amount, it will affect people. And therefore, it will be increased to 2,587.50 for your typical 2.5 years plus the 1,048. I put 1,048 as a standard. Bear in mind that some people who are here without leave and out bail will pay more. They pay more than 1,048. But if we take the minimum of 1,048, we're potentially looking at 3,620 pounds or 30 pounds. For a family or two, you're potentially looking at over 6,000 pounds.
That's a fortune.
Of course it is. I mean, how many people have savings of 6,000, even 1,000, even 500 pounds in their account? But I say to people, we've been doing this for so many months now that you don't have to pay if you can afford it. You can apply for a fee waiver. You can prepare. We've done the fee waiver. We've done a video on YouTube and Facebook that is there. I will find it, we'll share it, and make sure that we prepare people for January, so that if you don't have the money, you don't have to pay, because you can apply for fee waiver. We've shown you how to apply for the fee waiver and how to make a successful fee waiver application. So Kwaku, that's what it is. And it's coming, they've given us a long rope. It looks long, but it's not long.
No, January is just around the corner.
So for those people who are looking to make applications, this is the time to look at it. It really beats my heart and it really worries me that many people who are already contributing, and these are some of the lowest earning migrants in the UK. These are cleaners, and they work in the NHS and provide for poor people, look after old ladies and old men and disabled children, people with mental health challenges and developmental challenges. They do some of the most difficult work we saw during COVID time. The people who caught COVID most disproportionately were Black people, because we work at the low end of society, which be it hospitals and the community centers, or we do cleaning, all those things. These are very, very important work for the country to survive, because without us, those of us who work as cleaners, as porters in the hospitals, without us, COVID wouldn't have been defeated. But now COVID is almost eradicated. It's at a level that is not a pandemic. And it's due to a lot of work that was done by Black people. And unfortunately, we are the brunt end of this particular increase. And it doesn't look nice. It doesn't look nice at all.
Government Impact Assessment has recommended an increase of the levy. And from the 16th of January 2024, per applicant, it's going to be around £2,587.50 50 pence for 2.5 years. Well, BWF has always told us that if you have anything to do it quickly. And then Uncle Ben has said again this afternoon that if you can't pay, there is a way around it. Make an application for the fee waiver. If you have any difficulty, any challenge, or any further information you want to find out, talk to BWF Solicitors, 0208 493 7340, 0208 493 7340, or the emergency number 077 127 61884, 077 127-61884. And I'm also inviting you to be checking the website of BWF Solicitors. Uncle Ben has been putting out various articles that are of benefit to everybody. Sometimes they say if you want to hide something from us, you would want to put it in a book or somewhere. But I would encourage you to be reading, because when you read, you get a lot of information. So visit BWF Solicitors on their website, www.bwfsolicitors.com. www.bwfsolicitors.com. So visit BWF Solicitors Monday to Friday between 9:30 in the morning and 6 p.m. in the evening. Before I take a break and a quick one, let me recognize the wonderful people that have joined us. A few of them I've seen on the platform. If you join us, please indicate your presence in the comment section below. Dr. Sadom, hello, Uncle Ben and Brakweku, thank you very much, Doki. The next one, Sandra Fraser. Yes, you are doing the exact thing you do every day. We appreciate you. Sandra, thank you so very much. Ramanana Sewa, hello, everyone, you say. The next one says, Gifty Chan team, good evening, everyone. Please, let's copy the link and share. I like that. Thank you so very much. The next one here, Nanajima, please share. This information is something you would want everyone to have. SRTV Ghana. And you say top man. Yes, I know you're referring to senior partner, Uncle Ben. Yes, he's really a top man, and he's got the knowledge and experience to share with us. Brilliant and well done, BWF. Your Honor, QC Bernard. So this one from Issa Ayuma. The next one here, Tilly Duma. Hello, lovely family. Tilly, thank you very much for joining us. You've been a regular person on there. The Nigerian Senior Minister Brawa, and our class is going on. I love that. And a host of let's take a couple and we move on to our main discussion. Douglas 24, Uncle Ben's genuine selflessness and ability to create time for our community is unmatched. Thank you, Senia. Douglas, yes, I join in your appreciation and your expression of gratitude to Uncle Ben, because he's done that, and as he's mentioned, he's done that over 31 years, and he wants to continue to do that. And with that, let's pay tribute to the organization BWF Solicitors, and we'll be right back. And I just want to remind you that between the 10th and the 12th of November 2023, Uncle Ben will be a part of resource persons that will be advising us on investing in property in Ghana. It is the property lifestyle show that's coming up here in the UK. These messages, and we'll be right back.
Welcome to BWF Solicitors, a trusted and experienced family law firm specializing in immigration and naturalization, as well as dispute resolution. Meet Bernard Owusu, our esteemed senior partner with over 30 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stand for integrity, respect, excellence, teamwork, diversity and inclusion, and service to the community. We provide tailored assistance across all areas of UK and Ghana law. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Led by experienced senior partner Bernard Owusu, the team at BWF Solicitors is ready to assist you with your immigration, naturalization, dispute resolution, family law, new wills and probate, Ghana law and practice needs. We are dedicated to providing solutions to our clients' problems. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Main office line 0208 493 7340 or our emergency line 07712 761 884.
Ready for the ultimate property and lifestyle experience? Get ready for the Ghana Property and Lifestyle Expo 2023, coming to 2 exciting locations. Join us in London on the 11th and 12th of November, where leading reputable real estate developers will be waiting to meet you face to face. Be inspired by industry experts as they provide thought-provoking panel discussions and live Q&A sessions. And finally, mark your calendars for the 16th and 17th of December when the expo lands in Accra, Ghana. experience the vibrant lifestyle and rich culture of Ghana while exploring investment opportunities in the thriving real estate market. Our expo will also feature exhibitors ranging from banking and legal services to estate and property management. Get all the support and information you need under one roof. So whether you're looking to invest, visit or simply explore the world of real estate, the Ghana Property and Lifestyle Expo 2023 is the place to be. Don't miss out on this incredible opportunity. Book your tickets now via Eventbrite for the Ghana Property and Lifestyle Expo 2023. Dream it, live it. You don't want to miss out.
Thank you very much for sticking around with us, and welcome back to the discussion. The Community and the Law is brought to you by BWF Solicitors, our trusted partners when it comes to the law. Now, this afternoon, we're looking at running a very successful business and doing it right. Home Office approved sponsorship license as a business. We know about it as the certificate of sponsorship, you know, the skilled worker route, and especially when people are bringing in care workers to help the community here in the UK. Now, people put in the application, they are granted the certificate of sponsorship, and sometimes people come in here and we have had reports that people don't get work to do. But there's a lot of jobs. There's a lot. And a couple of weeks back, we spoke with St. George's Group, and they showed us how they have successfully run their business, and they continue to have contracts, and they're not running out of positions in any time. And you remember, on the day when we're having that discussion, one thing that stood out was business development. Business development. So if you sit back and you don't contact the right third parties, lawyers like BWF Solicitors, then definitely you might be sitting on some gold mine and you'll be getting it wrong. The traps and the pitfalls we're going to look at, and we're going to look at how we're going to avoid them. So I have said earlier on, and I'm going to repeat that, brought the main man himself, because he does a lot of work when it comes to setting up people, providing the third-party support services for businesses like the one you have and the one you intend to have. Uncle Ben, setting up this Home Office approved business to bring in skilled workers, how difficult is it?
Well, it can be as easy as you make it, and it can be as difficult as you make it.
Right.
First of all, I think the focus that we have this evening is on the compliance bit.
Okay.
The business development bit, as you rightly pointed out, was dealt with someone who still works in the industry with his wife, and they have businesses that do health and adult social care, and they've been very successful.
Mm-hmm.
So, I mean, those people in the industry, they are very successful businessmen.
Right.
And as I said, every person who is doing this work, before the Home Office made the shortage occupation, they've already had a successful business. Mm-hmm. They've been running their business for a long time, and they know how to run the care business. That nobody can tell them how to run it. So for that, they don't have a problem. What is additional duty is the fact that they've now got a sponsorship license, and that is what they haven't done before.
Okay.
So it's quite complex because it changes and some of the definitions are ongoing. So this afternoon, we will take 5 thematic areas.
Right.
And those areas are your reporting duties, your record-keeping duties, your duty to comply with the Home Office immigration rules, your duty duty to comply with the UK laws, and then your duty to ensure that your conduct does not cause or lead to anything that is detrimental to the public good. So those are the 5 thematic areas that we'll have, and that you can show them if somebody wants to copy it. So these are the areas that we're going to concentrate on. The reporting duty, the record keeping duties, complying with UK immigration, complying with the wider UK law, and not engaging in behavior or actions that are not conducive to the public good. So you can take it off.
Okay.
Now,
Maybe
yeah.
we'll pick them one after the other.
Okay.
Reporting duties. What's that? Is it on the part of the employer? Is it on the part of the employee? Or we could look at both of them.
Okay, so it's everything that we're talking about now is a business. So it's an employer, and the employer is a person who has a license.
Right.
So in this case, it will be the employer.
Okay. All right. So what duties specifically are we outlining here?
When we set you up for your sponsorship license, as part of the application, we will have to send them a manual that shows that you understand the Home Office rules and regulations, and that you've got a capacity and the capabilities and the systems in place to comply with the law.
Okay.
Part of your duties is what we call a reporting duty. Every person who is brought in migrants and has a sponsored license, you have a duty to report the migrant for certain incidents.
Okay.
So if they fail to report or come to work without your permission for 10 working days, then you have a duty to report within 10 working days. Sometimes it can be 20 working days.
Okay.
If you cancel their sponsorship, then you have a duty to report. If you lose your license or your certification from maybe CQC, you've got a duty to report to the Home Office. These are the main examples that I want people to understand.
Right.
Those are the reporting duties.
Okay.
Now, when we go to the other part, which is the record keeping duty,
Yeah.
when you're doing your processes, the processes that you do involves recruitment. The recruitment starts with advertisement or some form of announcement or broadcasting or cascading of vacancy. Whatever mode you use, because most of these areas are what we call non-compliant with the resident labor test. They don't have to do what we call a resident labor test. So really, they don't have to do advertisement.
Okay.
But as part of your record keeping, you need to keep records of how you recruited. Recruitment starts with engagement. How did this person hear about your business? So if it's through an agent or agency or through whatever means, either your website or through Indeed or through YouTube, LinkedIn, or Facebook, Home Office requires you to keep the evidence in 2 formats, electronically or paper. Electronically can be a PDF, a JPEG, a PNG, whatever it is that you're keeping. It should be document that has been kept, saved in a safe place, because you also have a duty to comply with the Data Protection Act and also the the Data Protection Act of 2018, and also the general requirements under the data protection laws, which is EU-wide. So whatever you're keeping or saving your data in must be data protection compliant.
So in this case, when you doing your application, do you have to add this as evidence that you have advertised the position and somebody is successful, so you need a license for that?
So, I mean, listen, we share information, so I don't mind sharing for people. When we make a typical application, we justify why you should get it. We just don't make the application. There's a lot of work that goes into what we do. So we gather a lot of data about the business.
All right.
Now, there are things that we do for them that they don't even know because we don't tell them. We capture information from social media, from their website, from company house, from CQC, and from other websites. We put all that information together, and then we use that to prove the existence of this company, and it's a company that is also advertising for business.
Okay.
So it shows the need to recruit from within and from without.
Right.
So wherever you're recruiting from, it may be word of mouth, it may be you've sent information on your website and you need to have a website, you can put the vacancies there, or you can use an agent. And some of these people use agents. Whatever you're doing, you have to keep a record
Records
of
of
that.
that.
And that record can be kept in two formats, either paper or electronic.
Yeah.
And as I've always said, I mean, I'm not a paper person, but sometimes paper is precious because it's a tangible thing that you can hold. So it's for some people, it's the best form of evidence. It doesn't matter. If it's in the paper, it's in the folder, you've got a cabinet and you've kept it there, that's fine. But the record keeping, you're supposed to keep your record with certain time. So for an employee, the records that you're supposed to keep is their data.
Okay.
Data includes name, date of birth, address, phone number, email, and next of kin. Those has to be kept. The other information that you need to keep is how you recruited them.
Okay.
It may be that you got them from Indeed or from some other place. You can take a screenshot, you can download, print as a PDF, and then you save it electronically. The other data that you have to keep is the interviewing process.
Okay.
The Home Office in the Appendix D, which is the evidence that they want you to keep. So those who are listening to me, the evidence the Home Office wants you to keep is called Appendix D. The Appendix D requires that you keep this evidence: how you recruited, how you selected, why you selected this person and not that person, their CVs and application forms, they all have to be kept. Ongoing training has to be kept. Once you've done that, if people are coming to you or you recruited them initially, how were you able to check that they're allowed to work for you? Again, you have to keep that. So the employer checking service or the ECS or the share coding system using their residence card to do online code share coding to check. You've checked all this, you kept it. That information is supposed to be kept till 1 year after the person has left your employment,
Okay.
or 1 year after you've had a compliance visit. Every person who has a Home Office sponsorship license will have a compliance visit.
How often is that?
It's as often as once in 4 years,
Okay.
because your license is given to you for 4 years, and they will either come and visit before they give you the license, or they will come and visit during your license, or they will come and visit when you apply to renew it, because you can make the application maybe 2 or 3 months before your license expires. A lot of them are about 2 or 3 years down the line. So very soon they will be making applications for their renewal.
Okay.
And these are some of the evidence that they will look at. Once you've kept all this, the other thing that I always advise people to also keep is the evidence of how you pay this person. So under Appendix D, you have to keep your pay slips, PAYE, the NI you paid, how many hours they work for you. Now, it's not kept in isolation. The reference point is the COS.
Okay.
Because the COS is a certificate that you've issued to the migrant. And on the COS, there are 2 major things that you state. If you don't state them, you won't get a COS. It will be rejected. One is that I will pay this person £10.75 an hour. 2, that this person will work a minimum of 38 hours. So you have to keep the pay slips, the PAYE payments, and this has to be kept for a year, until a year after this person is left, or a year after the compliance, or as long as this person remains with you, you have to
You have
keep
to
it.
keep those records, yeah.
The other thing that you also have to keep is that when you cancel a COS, you have to justify why it's been canceled. If it's because the person has failed to report or the person has been dismissed, this is a record that you have to keep. And these are legal exercises that you have to do. So, for example, if you look at the 5 thematic areas, the 4th one is complying with the UK-wide law. That includes Employment Act, Employment Rights Act,
Okay.
the 1996 employment. So if you say this person came to me and she was pregnant and therefore I've terminated a contract, pregnancy is one of the protected areas that can lead to an automatic unfair dismissal. So you have to be careful.
Yeah.
And I'll explain why these pitfalls must be avoided at all costs. As a business, you need to have resource around you, and we call it the back office. So most of this business, we work at their back office for them.
Okay.
We advise them on employment rights, on what they need to do, on the updates, the documents they have to keep, and what evidence that they need. What we don't advise them on is how to do the care business. That we don't advise them on, but we advise them on the law. And we are looked at as third parties because when we make an application for you, the Home Office will ask us, who else have you applied for license for?
Okay.
Because they're checking our track record. And that is why it's very important that whoever is dealing with your case, they are either an approved, accredited, and I would say a solicitor. It doesn't mean that somebody who is doing OIS cannot do it. But I'm saying that there are people who are dedicated to this business. And because I run this and have run it successfully for so many years, we know what will help you and what will not help you.
Okay.
But the bottom line is that even if you're going to somebody else, they are very basic, these 5 thematic areas that you cannot avoid.
So we've looked at reporting duties.
Yeah.
We've looked at
Record
record keeping, which
Yes.
is quite extensive and very important.
Yeah.
The third one is complying with immigration laws. Obviously, somebody coming into this country to live and work would have to follow the immigration rules. Are there any specific things and areas that people will have to take note of? Or is the general immigration thing that everybody has to follow?
Okay, so as a business with a sponsorship license, you have a duty, 1, not to employ illegal migrants, 2, to make sure that when you're employing, there's a manual that we create for you, that is a manual that you follow to employ people, and you do your right to work check-in. You need to follow that. 2, you also have to make sure that when you say that I'm recruiting, as part of your duties, that recruitment and the vacancy has to be genuine. So there has to be a genuine vacancy. So if there's a genuine vacancy, it means that there's a job for this person to do.
Okay.
And if there's no job for this person to do, that is why, as far as I'm concerned, those businesses that are not doing what they should be doing on compliance, I'm afraid they will have 3 things happen to them: suspension, condition, or revocation. I'm afraid it's a big thing because when we make your application for you, we write a story. The story we write, we look at your business. So we interview the business people. We understand your business. We then take the information that you've provided us. We use our in-house expertise to draft what we called a business proposition to the Home Office. And as part of the business proposition, we always tell the Home Office that a Kia Mansa enterprise will comply with the immigration rules.
All right.
As part of the immigration rules, we need to justify that you need to bring people from outside or employ people from inside the UK who are migrants. And to do that, we need to show that there's a genuine vacancy. What is a genuine vacancy? A genuine vacancy under the Home Office rule is that at the date that you advertise and recruited that person, there's a vacancy for the person.
Yeah.
There's a vacancy for the person. So when you recruit them, you train them, they do on-the-job training for 2 weeks, 1 month, 2 months, whatever time. But when they are ready to work, there's work for them to do. There's all sorts of business development propositions. I'm not going to go into that because these are very specific to each businesses. If the person's business is such that they're struggling to get contracts, There are things that they do. Some of the business that we work for, they do a very, very unique way of getting business to help their business and to make sure that even if they recruited 200 people, all the 200 people will have work. Because remember, every person that you're recruiting, a prior approval is given by the Home Office, and they know the person. They know their NI number, they know your PAYE. So in 2, 3, 4 years, when they come and do their compliance visit, they can come to you and say, Mr. Johnson worked for you in 2022. Please bring his file. We are in 2023. It's not a year yet. Bring his file. We want to see his pay slips from January to December. We want to see how many hours he worked for you and how much you paid him. If you don't have that, then you haven't done record keeping. If you have that and the position was not a genuine vacancy, then you will not have pay slips for 1 year. Or even if you had, you will not have paid them at the level you said you would pay them for 1 year. And that is a breach of your duties. And because it's a breach of your duties, it's very likely that you have one of 3 sanctions: condition, which means that they will ask you to do certain things before you can proceed. Suspension, which means that you can no longer recruit, but you can retain the people you already have. Or revocation, which means that you cannot recruit, there's nothing for you to do, and the people that you already have in your employment, you will have to let them go. The only people who can work for you are people who are already here and have their residence. The sad thing is that, and I'm afraid I have to say this, as I hear, not see, because those I see are businesses that are run properly. Every person that I know who's doing this business is running one of the most successful businesses in the UK. And I keep saying, remember that 3, 4, 5, 6 years ago, they were doing this business. And they are very successful people. They don't need this to be successful. But this has come because they want to retain the staff. And that's why they're doing this, because the care industry.
Sorry, obviously somebody who's run a successful business for a minimum of 5 years wouldn't want to jeopardize the future of his or her organization by doing things not the right way. So obviously, I don't expect them to do the things wrongly, and they will comply.
That's correct.
Moving on, we're looking at the 4th one, which says that complying with wider UK law when it comes to employment. Illegal working is one of the things you would want to look at. But how do we define illegal working? Somebody has come through, have properly advertised. The person has successfully got the employment. I brought the person in. What would make somebody an illegal employee?
So if, let's say you have a student.
Yes.
He's got a residence card. He's at the University of Colchester. Term time, he's supposed to work 20 hours.
Yeah.
But you put him on your rota. He's working full-time, permanent, and he's doing 40, 50 hours a week, and he's on your rota. That's illegal.
Okay.
Somebody is an asylum seeker, is a failed asylum seeker. Somebody is an EU applicant. He's a failed EU applicant, but they come to you with a document. You don't do your ECS, employer checking service. You don't do your share coding, or you haven't checked the documents. There's no excuse for that. You will be subjecting yourself to a £50,000 fine or losing your. So that's one of the areas. The other area, which is the wider UK law, is employment. And every business that employs people must abide by the ACAS Code of Conduct or guidance in relation to dismissals. Kweku, most of these businesses have genuine need for people, genuine.
Yeah.
Unfortunately, there are people, when you employ them, they think that they are untouchable. So I've had a case where somebody was working for a business and the opposite sex, they were having sex in the facility. They were having sex. They were sleeping with themselves in the facility.
Whilst you're working?
Whilst they're working. And the man was sleeping with 2 women, and the women were fighting with each other because one man sleeping with 2 women in the facility. What the other people were also doing was insulting the owner of the business and her husband. And she obviously she saw and heard it. There's record of that. And one person took one of the inmates for a play group, and she was engrossed on her phone, and therefore they lost this person for 3 to 7 days, and this young person wasn't found. He was lost because this person who was supposed to watch over him or be the chaperone, make sure he protects this person, because some of these people are people with mental health issues, people with physical challenges, and people with developmental issues, and therefore they always need help around the environment that they live. Now, if this person has employed you and you've done this to them, if the social services gets involved, it's very likely this person will either receive a caution, lose their contract, or their contract will not be renewed, because some of these contracts are 2, 3, 4, 5 years. So they renew them at regular intervals. Therefore, for me, this is gross misconduct. And gross misconduct, you don't have to come back to the police. Straight away, they have to dismiss you. But once you dismiss the person for gross misconduct, you can do that on the phone or with a text message, that this is to formally dismiss you because your behavior is gross misconduct. Once you've dismissed them, we then fall back on your employee handbook. And I keep saying, every application that we have had, they all have employee handbook, all of them. So the employee handbook would tell the employee what is a gross misconduct, what is a misconduct, what is a verbal warning, what is written warning, what is final warning, what are the processes for dismissal, for suspension. These are well documented. So once you've sacked the person over the phone through a WhatsApp or through voicemail, you then have to formally write a letter to them and say, "Dear Ekuyatenewa, on this date, you took this person out, and as part of your duty, and you refer to the section of their job description, you were supposed to do A, B, C, D. Because you didn't do that, and you were engrossed on your phone, and they've got video of her captured, because it was a security area. So there's a video. You were engrossed on your phone, and he then escaped. This is why he escaped. We were supposed to protect this person. We haven't, and that is why we've dismissed you. You've got a right of appeal. If you appeal, we'll meet you. You can call me. You can come and do the appeal here. We'll listen to them. We'll judge. We'll do a report. We'll give it to you. The dismissal is justified. They don't have a right. But the right is subject to Section 108 of the Employment Rights Act of 1996, which is that if they haven't worked for you for 2 years, then they can only sue you for automatically unjustifiable reason. If somebody is committed an offense of the nature that I've said, or insulting the owner who has employed you and pays you and her husband on a daily basis.
That's gross misconduct.
Of course it is.
Gross misconduct.
It's gross insubordination.
Yeah.
And gross insubordination, for me, is a gross misconduct. And when they are dismissed, you have to be sacked straight away. If the person has done this and taken steps, and that's why I refer to the ACAS guidance on dismissal, every employer must have that. Even as a lawyer, I have that. Then the person cannot come back and sue you. They may attempt to sue, but two things. Because they haven't got what we call the statutory period under Section 108, then Section 94 will not apply. And because Section 108 doesn't allow them to do that, then clearly there's nothing. But if you just say you are dismissed and that's it, you send them a WhatsApp and say, "I've dismissed you," and you don't follow your own processes, then that's a breach of contract. That is how then they can sue you for a breach of contract. And these are some of the reasons why they say, as an employer, to run a successful care business, you need to follow the wider UK law, and that includes employment law, and that you're giving them their holidays. When they are due for statutory maternity pay, you pay them. Sickness pay, you pay them. Statutory sickness pay, you pay them. All this is documented.
All right. And that dovetails into the last bit of the categories we're looking at. Not engaging in behavior that's not conducive to the public good. Not necessarily behaving very well or whatever within the organization, but within the wider community. Can you take us through that as well?
Okay. So not behaving in a way or actions that are contrary to public good is wide. Remember last year when we did a revocation of British citizenship,
Yeah.
we referred to this.
That's right.
So easily what comes to mind is, you're here, you're encouraging people to commit fraud, or you say that you are a fair employer, you're not following the UK laws, you're employing illegal migrants, or in certain regards, you may have been found to have committed fraud, or you're doing something, or your organization is doing something that is detrimental to UK national interest or public policy. Kweku, this is as wide as a yardstick. The problem is that it's so wide, it includes any bad thing that you can think of. It may be anything. It may be somebody reporting you for something you've done, somebody, it may be investigation under something, money laundering. It may be so many things. And that is why I always say, when you get a license, it's not the end of the world. When you get a license, unfortunately, you've taken on a lot of burden, including the burden to satisfy the local authority or the CQC people and to satisfy the Home Office, but also to satisfy the laws and the regulations that is required under your sponsorship license. If you follow this religiously, if you have a system in place, if you have a system in place to check all this, then clearly you will not be found wanting. It's very easy to achieve because it's 5, but it opens up into other areas. For example, we've talked about genuine vacancy. We've talked about relevant skill set and all those things. Those are things that can affect your business. But again, as I keep saying, every person that I know that runs this business, that I have association with, they are one of the most shrewd people in business, and they've been running this business successfully for so many years.
We live on the Community on the Law, and senior partner of BWF Solicitors, our proud sponsors, and of course, our main benefactors, is helping us unravel this issue of avoiding pitfalls when you're running a successful Home Office approved sponsorship license as a business. And he's taking us through some of the areas you need to look at. Reporting duties he's mentioned. There is record keeping duties that any organization would have to undertake. Complying with immigration laws, he's mentioned that and explained. He's taking us through complying with wider UK law when it comes to employment and not engaging in behavior that is not conducive to the public good. It's as wide as anything. It could include anything, as Uncle Ben has mentioned. We're taking a quick break, and when we come back, I'll be looking at quickly 3 areas that you need to provide or look at as a requirement: the genuineness of the vacancy, the salary that has to be paid to the people you have employed, and the skill level. Skill level is relative to whatever area you are engaging in. And what are some of the things you need to look at? It's a community on the law, and today we're learning how to run a successful business and avoiding the pitfalls and the problems. BWF Solicitors, 2142218 Tottenham High Road, Seven Sisters, North London, for all your immigration issues, for all your family issues when marrying and divorcing and all the other bits of it, and especially when it is that you need legal advice. Talk to BWF Solicitors, 0208 493 7340 or 077 127 61884. We'll be right back.
Our private client services team is recognized for providing clear and practical legal advice to our clients in the United Kingdom and Ghana. Expert help with will writing, probate or estate administration. Our will writers and probate lawyers can act for you to obtain grant of probate and carry out estate administration on your behalf. The probate takes place after someone dies. If there's a will, the named executor is responsible for ensuring that the estate of the deceased is secured, assessing its value and paying any inheritance tax. If there is no will, the interstate and inheritance rules require similar responsibilities. Our lawyers offer strategic and practical solutions to the issues which clients face, whether it's in relation to succession planning, will preparation, probate and the administration of estates, immigration and visas, contentious family or probate disputes, administering estates often with inheritance cross-border issues, international trust advice including residence, domicile issues, wealth preservation, a fast, efficient service from SRA-regulated professionals, transparent pricing. BWF Solicitors. Let us take care of probate.
It's our platform as well. Well, we come back and thank you very much for the time and your attention as well. We having a discussion on doing things right and running a successful business when it comes to skilled migrant route and the certificate of sponsorship. Uncle Ben, the senior partner of BWF Solicitors, has graciously taken us through the steps we need to take before we do the right thing. And the advice has been that you need to engage third-party organization to help you do this. There's one question I wanted to ask Uncle Ben. You know the 5 steps you took us through, Uncle Ben? It's a very detailed, tedious, and somewhat difficult thing for small organizations to be able to do. I would want to probably reiterate that is it ideal to engage a third party to do some of these things for you, especially your HR stuff and the finance bit, the accounting of all the details and the rest of it. Is it ideal to do that?
Well, first of all, this business will have an accountant who's a third party. They may have an HR person, but as lawyers, we always, those that we look after, if they have any HR issues, they can always bounce and off us. We don't charge them. It's something that we offer as part of our services. They can also engage a lawyer to look after this monster. And it's an octopus with many, many hands. But the 5 thematic areas are the most problematic of all the areas. Because if you take each of the 5 areas, they are broad topics in themselves. And therefore, I always say the most successful people are those people who use all their abilities and talent, including recognizing where they haven't got the ability. And that means that it will make you get extra hand. It doesn't cost a lot. We have a relationship with a lot of people. And I always say that as BWF solicitors, because we're community lawyers, once we do the initial application, so far we have 100% success rate and it's successful. Most of them stay. Some obviously move on. They go and do their own things. That's fine. That's no problem for us at all. I say that those that have stayed with us, they are very confident that even if it's midnight and they call me, I'll pick my phone and help them. And those businesses, it allows them to concentrate on running their business as a business, because that's something that they've done for many years. The additional responsibility is not something that they've done for many years, and that is why they need support, and that is why we are there. HR software, if you have more than 20, 30, 40 employees, of course, you need a system in place that will capture all this data and the holidays and stuff like that. So that's fine, you can have that. But where it comes to processes, say, okay, Uncle Ben, this employee hasn't reported to work or this is what they've done. We will then sit down, I'll listen to the employer and I'll say, okay, you need to send this. We can do a template for you, but also the template is on ACA's website. You can go and download it. ACAS is one of the most used voluntary organizations that is created by the government, and they help both employers and employees. So it's not a one-way stream. It's not only for employers, but it's also for employees. And even when employers and employees have an issue, you can call ACAS and they will resolve it for you free of charge. And therefore, they are very, very a good resource, a very good resource for business. But the monster that we have, which can be for good or for bad, is those 5 thematic areas that I've listed. That you will not always have the capacity to do
Yeah.
because it's typical example. You're employing 20 people. You're starting with your announcement, which may include advertisement on your website or not, or through an agency or not, your recruitment processes. Once you've done the recruitment, where are you keeping all the paperwork? When we come in, we do an assessment. Part of the assessment we do is to assess the eligibility of this person to meet the Home Office requirements. All the processes that we go through is electronically generated. So when we generate, we give it to you as a folder,
Okay.
including the application, the payments, the biometric cards, the grants, and everything. So you've got a complete folder. So if you bring Johnny and Antonio to us, and we've done all the assessment, we've taken them through, we've issued them with the COS, they've done everything, you've employed them, we've got all that for you. So what you need to do is to keep that folder. And then as he's working with you, you're also creating more information, generating electronic data, and you're adding it to the folder that you have. So that when the Home Office comes for compliance visit, which they will come, if they haven't come yet, it means they haven't reached you, they will come. When they come, easy. What we do is that when they're going to people, they call us, maybe a week before they go, we go in there, we do a mock, we splash around, we do a proper interview, we interview the workers, we interview the managers, just to make sure that they're saying the right thing.
You comply.
It's very important because the manager might say one thing, and then HR manager might say a different thing. And then, the supervisor might say something, and then it's not coordinated. So that we make sure that once we've done that, we then do a report for them. We then tell them what their shortfall is. And everyone that I've done, we've had inspection before, because we are also a sponsored organization. So we employ, we have license to employ people from outside. So, we had one, it was almost about 5 hours of interview in my room and going around and speaking to people. So we know what it takes to overcome some of these things. Yeah.
Well, maybe to round up, let's look at some of the employment requirements that have to be met. I can probably recollect the genuineness of the vacancy, the salary that has to be paid, and the skill set, the level that have to be
Time.
met. Yes. Would I be right?
Yes, and the hours of work.
Okay. So, what kind of salary do I have to?
Now, when you
what
take
do I
care
have to
work,
do?
I think the hourly rate now is £10.75 per hour, and you do a minimum of 38.5 hours or 37.5 hours. Some people do 40 hours, and that will give you the minimum income. Just remember that care work, social work, health and social care is one of those areas where you don't have to get a full income, and their level is, I think, £10.75 an hour. So once you've done the £10.75, you multiply by the weekly hour, that will give you the minimum pay for the person.
Do they have to pay beyond the minimum or strictly the minimum?
Everyone that I know, usually, some of the people that I work for pay above.
Above. Okay.
I have one that pays £11.50. I have another one that pays £11. I even have a business that pays £12.25. And it's a business, is a way they want to run their business. Yeah.
Okay. All right. Now the skill level. Let me concentrate on the care worker route because that's the most common one that people are engaged in. What kind of skill level does one have to have? It's prescribed in the application.
Okay, so if you want to talk about skill level, what you look at is a JD, which is a job description. So it's a job description that will tell you the skills that you require. It's
Correct.
not magic. If you say, I want somebody who has experience in this area, and you recruited someone who hasn't got experience in that area, you need to justify it. And remember, I told you about record keeping. The records you don't have to keep are the people that you didn't recruit, but you have to keep their applications. You don't have to keep their CVs or their interview records. The people that you employ, you have to keep their interview records. So the interview records, your JD or your job description, and then your statement of employment or employment contract, they will all have the skill set. It's not magic.
Anyway,
So if the Home Office comes and you say you want somebody who's done care for 1 year, and Araba Mansa is working for you, and Araba Mansa hasn't done care for 1 year before you employ them.
and you fall for all of that.
But that's why when we look at your JD, we tell you this, some of these are desirable, some are mandatory. If something is desirable, it means this is what I want. If I get it, I will like it. But if I don't
get it, it is not the end of the world.
because it is not a requirement. There's a difference between a requirement and a desire. So the preference is for this. So I want somebody who's done care for 1 year, but it's not mandatory. It is a desirable. So if they come and they check and this person hasn't done care for 1 year before they employ them, it was a desirable job description. It was not a mandatory job description. Speaking English is one of them. So again, that's why you have to pass the test. And I now have heard that there are people who are creating certificates for people which are fake. Please stop it, okay? Please just stop it. Because you're causing
People always take undue advantage of
I don't
situations.
understand. I mean, someone called me, and he's got 4 people who have had that issue. You know that they said go and sit for exams. You know that you haven't sat for exams. Why do you take that certificate to an employer and say that this is my certificate, I've passed an English test? Because you know you didn't sit an exam. And we know where the exam is at. If you're in Ghana, at British Council. So if you went to do an exam in somebody's bedroom or somebody's shop or container shop, and they've given you a fake certificate, including university fake certificate, the UK government will catch you. They might not catch you today, they might not catch you tomorrow, but as with the nuggets that we're doing next week, they will catch you. And when they catch you and you've reached your crescendo, you've got a British citizenship, they will bring you down like a ton of bricks.
Oh my
And you
goodness.
lose your British citizenship. So
Would have
please,
wasted all your years.
Kwaku is not only wasted, but you've caused problems for your family. Because everyone that I know in the UK will have 2 or 3 people that have duty to support or some desire to support, and they support people. So if you're now fighting, you're going through lawyers to fight and retain your British citizenship, and because of something silly that you did maybe 10 years ago, it's a problem. So please, if they say bring English certificate, if you go to university, genuine English certificate, please bring it. If you haven't got, go to British Council and go and pass that test.
Well, it's a very simple test to pass, so I don't expect people to just cut corners and get themselves into trouble. We're having a discussion on how to successfully run a business that's approved by the Home Office to bring in workers on the skilled worker route. The community and the law is what we are on now. It's brought to you by BWF Solicitors, our trusted partners when it comes to the law. Now, if you have any question or concern, you can bring that one up. The studio numbers are 07399208468, 07399208468, or you can send us a voice note or a WhatsApp message on 07950 422 780. 07950 422 780. Our guest and resource person is a senior partner of BWF Solicitors, Mr. Bernardo, who we all call him Uncle Ben, and he has been so detailed this afternoon to tell us what we need to do and the rest of it. I have people who are sending questions and concerns via the comment section on Facebook and YouTube. We'll be looking at that. Don't worry, it could be about the topic we have discussed this afternoon, or it could be any other legal matter that you want to bring across. Let me pick this one first. Uncle Ben is ready to do that. My friend Divine Provision, that's what you say your name is. Let's pick this one. I'll put it on the chat, and so others can also see that. I'm going to read it from the phone. You sent it as a WhatsApp message. Prof, if you have it, can you please? How can I make the following corrections for my child's name in Ghana? Child's correct name is gives an imaginary name, Wisdom Kofi Atubam. You copied it from Uncle Ben. The name is correct on all ID documents as passport, birth certificate, child health records, and the rest. On non-ID documents like all school fees and hospital receipts, prescription forms, pharmacy receipts, the name is arranged wrongly, no hyphen sometimes. It is a big deal. Is this a big deal? That's a question in child visa application using sole responsibility. How can this be corrected in Ghana?
Okay, so as we all know, officialdom makes mistakes, and once they make a mistake, I always advise people to go back and have it corrected. I've seen a Siedu spelled Asiada, and the person said, "Well, I'm okay. I'll use it." I've said, "No, you're not going to use it. You have to change it." Sometimes, if you don't have school certificate and you're using your qualification to work, maybe you might get away with it, but if your name is spelled wrongly, it has to be changed. Whoever spelled it wrong must change it.
Okay. Somebody says, hey, someone walked into the office to ask if we give fake English certificates. I said, please, you are at BWF Solicitors. We are allergic to fake stuff. Thank you, Sandra, for that. My next question, Uncle Ben, is one from one of our listeners and viewers. The person says, I'm a Ghanaian. My British wife, who is a Ghanaian descent, of a Ghanaian descent, I think so, came to marry Mr. and brought me, came to marry me and brought me to the UK. I understand typos sometimes do happen. Now I've got British citizenship. Marriage of 5 years is broken down irretrievably, and I have applied for divorce in UK 7 months now, but no decision yet. So I went to Ghana in February 2023, met a new lady I want to marry, and brought her after divorce has gone through. Please, I went to Ghana again last month and went to court to apply for divorce because the initial marriage was done in Ghana. The court sat down with families and called my wife from UK, and they agreed for a divorce. The UK divorce is pending, and I don't think it will be necessary because I've got notification that Ghana divorce has gone through. Please, will the Home Office accept the divorce made in Ghana court so I can marry my new woman?
Yes, the Home Office will accept divorce from Ghana if it complies with Section 46 of the Family Law Act of 1996, which covers international divorces and divorce otherwise obtained by the legal process. This will have to be obtained in court, not customary divorce. Because the judge is involved and you said the court called your wife, I assume that this is a court process divorce and it will be valid in UK. However, once you've come to the UK, you need to withdraw the one that you have in court. It's very easy to withdraw. You make an application and withdraw the divorce, and that will be withdrawn, yes.
Okay.
But you can use the Ghana one to marry your wife in Ghana.
Okay. The next one here, Ben, is I think this person has been following the program, and I congratulate you for that. I listened to the director of St. George's Group, but they were not specific on whether they can support new providers go through the registration process. I don't think they actually mentioned that they can support people go through the registration process. What they specifically advised was that use third-party organizations to help you do that. Would that be right, Uncle Ben?
So what St. George's does is people want to go into care. Sebastian is a business development specialist. He develops businesses. The application process will be done by us, but he can help you to go through the CQC process, show you what systems you need, how to bid for contracts. It's very good in bidding for contracts. The ladies that run these businesses are some of the shrewd business women that I've met. And when we say business development in the corporate world, it means a lot of things, but also for small businesses like yours, it also means having a regular flow of business so that you always have the need to provide new employees and work for your employees and to make margins on your income. So that is what Sebastian will help you to do. He will help you develop your business. I have many people that helps to develop business plan and all those things. Sebastian will help you in the care industry to get your certificate and everything. And then we will help you to get your sponsorship certificate if that's what you want to do.
Okay, thank you very much, Uncle Ben. One here says, my mom wants to visit and sponsoring herself, but will be staying with my family. I'm currently struggling with severe mental health issues and also an expecting mom. I made an application to renew my BRP 2.5 year leave to remain and haven't received a decision yet. Can I please add my letters from my clinical psychologist and my trauma intervention plan to my mom's document, which she will be submitting to the Home Office as a reason for visiting? How many months can she stay, and what are the requirements both from my side and herself? I receive public funds.
Yes, mental health is one of those most difficult areas. Was it this month or last month? We celebrated mental health. Was it week or month?
Last week, last.
Yeah, and everybody who's going through psychological trauma or mental health trauma, they need all the support that they can get from family. And this lady, I'm not sure I know this person, but if you come, we will help you free of charge. Just say that Uncle Ben said I can have free service. Let me know by WhatsApp or email when we finish the program on Monday, and our office in Ghana will sit down with your mom and we will craft something nicely for her to come and support you. I think she said she's pregnant as well this year.
Yes.
Yeah, so you need all the support. And I hate to see people going through this particular insidious disease. It's not something nice, whether it's depression or psychosis or schizophrenia or the other ones, they are not very nice disease. And anybody who's going through that needs all our support.
The community and the law, and we are you're coming your way by courtesy of BWF Solicitors, and we're fortunate to have the senior partner himself helping us as a resource person. So keep your comments and your questions coming through 07950422780. That's for WhatsApp. And the studio numbers, if you want to call or text, 073 99208 073 how to run a successful home office approved sponsorship license as a business, the traps and pitfalls to avoid has been our main topic. But we're still picking up some of the other relevant things that are bothering people. Uncle Ben, this one here says, I'm going to put it in the platform as well. Just picking it up from a comment section. It says, a friend of mine was refused a visitor's visa, and he wants to know, can he reapply since he's now married to someone and the partner has gotten a sponsorship as a healthcare assistant and wants to add him to the application of the partner?
Not many people call me Mr. Husu, so let's see. Good evening, Uncle. I think Mr. Husu is me. Yeah, it's Kweku. I'm okay then. My Uncle Ben is absolutely fine. I'm uncle to everyone. Yes, why not? So if you were refused a visitor visa, you can always reapply for visitor visa settlement. In this case, you say COS, a skilled worker route, which is a settlement route as well. So yes, you can. All that I say to you is that I hope that they haven't provided any false information, because we've looked at this before. every case that has come to us from outside which is refused, and there's a chap who's put something in the platform, I don't want to mention his name, and they have refused them because of paragraph 9.7.1. When we discussed it, we discussed discretionary refusal and mandatory refusal. We discussed discretionary refusal and the mandatory, and we also discussed that in this area, because it's discretionary, the Home Office said unless there's a dishonest intention, the person must not be refused. So yes, the fact that you've been refused a visitor's visa before doesn't mean that you cannot apply for any other area. You can.
0739208468. Well, if you want to call me Mr., then add those. Well, it's all good. We're moving on. I think we'll take a few of the comments and then we'll go to our our quiz section. But before that, Prophet, can we look at our nugget again? So maybe I will get people to refresh their memories on that. SSHD, that is the Secretary of State for Home Department, has discretion to remove the no recourse to public fund condition for students and their dependents. Failure to lift may amount to unlawful conduct under public law. The 1971 Immigration Act provides the Secretary of State with the power to exercise discretion in considering whether to vary the conditions of any leave granted, including the lifting of no recourse to public funds from permission granted on all immigration routes. The SSHD has now issued an operational policy instruction, OPI, to this effect. Now, let me go on to this one. That's a commendation, so to speak. Great programs. I'm yet to experience your great service. Can't wait to have the process started. Great job, sir. Is one from Ghana. Yes, BWF Solicitors has an office in Accra. So if it is that you want to have the benefit of their service back in Ghana, please do not hesitate to contact BWF Solicitors at the Accra office. I'll be giving you details and it will be showing on your screen pretty shortly. We're now going to have a quiz, and I intentionally brought you the nugget. Think about that. Can I even have it again? Because I'm going to take a quick break. So can I even have it again and see how many people will catch a gist from the nugget when I put the question and the scenario on? The Secretary of State for Home Department has discretion to remove the no recourse to public fund condition for students and their dependents. Failure to lift may amount to unlawful conduct under public law. The 1971 Immigration Act provides the Secretary of State with the power to exercise discretion in considering whether to vary the conditions of any leave granted, including the lifting of no recourse to public funds from permission granted on all immigration routes. The Secretary of State for Home Department has now issued an operational policy instruction, OPI, to this effect. And my brother, or the friend that I said I was going to give you the Ghana number, it's 00233, or if you're in Ghana, it's 0555 895 959, 0555 895 959. Or you can visit the website and send an email, or to visit any of the social media platforms. BWFsolicitors.com is the website. And I've mentioned earlier, and I'm going to repeat, that there are very nice, beautiful, very insightful articles that Uncle Ben has been writing. And I think we have a minimum of an article a week, sometimes twice in the week when issues come up, and he updates us so very well. So visit the website as well, bwfsolicitors.com. The community and the law will be right back.
Welcome to BWF Solicitors, a trusted and experienced family law firm specializing in immigration and naturalization, as well as dispute resolution. Meet Bernard Owusu, our esteemed senior partner with over 30 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stand for integrity, respect, excellence, teamwork, diversity and inclusion, and service to the community. We provide tailored assistance across all areas of UK and Ghana law. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Led by experienced senior partner Bernard Owusu, the team at BWF Solicitors is ready to assist you with your immigration, naturalization, dispute resolution, family law, new wills and probate, Ghana law and practice needs. We are dedicated to providing solutions to our clients' problems. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Main office line 0208 493 7340 or our emergency line 07712 761 884.
Ready for the ultimate property and lifestyle experience? Get ready for the Ghana Property and Lifestyle Expo 2023, coming to 2 exciting locations. Join us in London on the 11th and 12th of November, where leading reputable real estate developers will be waiting to meet you face to face. Be inspired by industry experts as they provide thought-provoking panel discussions and live Q&A sessions. And finally, mark your calendars for the 16th and 17th of December when the expo lands in Accra, Ghana. Experience the vibrant lifestyle and rich culture of Ghana while exploring investment opportunities in the thriving real estate market. Our expo will also feature exhibitors ranging from banking and legal services to estate and property management. Get all the support and information you need under one roof. So whether you're looking to invest, visit or simply explore the world of real estate, the Ghana Property and Lifestyle Expo 2023 is the place to be. Don't miss out on this incredible opportunity. Book your tickets now via Eventbrite for the Ghana Property and Lifestyle Expo 2023. Dream it, live it. You don't want to miss out.
Well, we moving and soldiering on, and we live on BWTV. Now, my question, I'm going to bring a scenario, and I want you to see if you can really catch and get me the right answer. Ajoba arrived in the UK as a student dependent to join her husband. While here, she separated from her husband, and before her divorce was finalized, she had a child with another man who was a British citizen. She obtained a passport, a British passport for her child, but the passport was subsequently revoked. Ajoba applied for the no recourse to public fund condition as a student dependent to be removed because she had no income and was allowed to claim, he had no income and was not allowed to claim benefits. That's what's supposed to be, forgive me for that. What is likely to be the decision of the Secretary of State for Home Department? As a student dependent, she must show she can support herself and that no recourse to public funds will not be removed. The Secretary of State for Home Department has the discretion to remove any condition attached to any leave under the law. And 3, as a child is a British, as her child's British passport has been revoked, she cannot apply for no recourse to public funds to be removed. So these are the 3 scenarios. As a student dependent, she must show she can support herself and that the no recourse to public funds will not be removed. Okay. The Secretary of State has the discretion to remove any condition attached to any leave under the law. And 3, as a child's British passport has been revoked, she cannot apply for the no recourse to public funds to be removed. Uncle Ade, please take me back. I still want to be very so take me back to the nugget. The Secretary of State for Home Department has the discretion to remove the no recourse to public fund condition for students and their dependents. Failure to lift may amount to unlawful conduct under public law. The 1971 Immigration Act provides the Secretary of State with the power to exercise discretion in considering whether to vary the conditions of any leave granted, including the lifting of NRPF from permission granted on all immigration rules. Now let's go back to the question. So, what are your answers? Can we see that on the platform? Let's see if anybody is going to get it right. As for this one, if you get it wrong, I'll be very upset with you. I'll be very upset with you because I think I've given you the answer, haven't I? I have given you the answer. Well, let me also remind you, next week I'm coming your way with some testimony, a testimonial. You know, the gentleman that won the prize for our Christmas quiz week, I caught up with him on his flight to Accra, and I'll be telling you how excited he was, and I'll be telling you about that. And remember, at the end of the year, we will be coming with our quiz again. So look at all the nuggets, take note of all of them, and the quizzes, and I'll be asking you questions about that. Prof, do we have any answers on board now? Let's see what we have. As a student dependent, she must show she can support herself and the no recourse to public funds will not be removed. The SSHD has the discretion to remove condition attached to any leave under the law. What law is that? Shall I tell you? No. As a child's British passport has been revoked, she cannot apply for the no recourse to public funds to be removed. Let's see your answers quickly before we go back to Uncle Ben to help us answer that and also give you further explanation as to what we really meant. And remember, on Monday before noon, the nugget will come up, and I think Uncle Ben is giving an indication as to what is going to happen. We're going to continue giving you some information that will help you look at the care worker route and the student dependent situation that we're having now. Number two, Zakaria Frimpong. Yeah, our friend that sent us the message from Ghana says the answer is number two. The SSHD has the discretion to remove any condition attached to any leave under the law. Who else has anything? Okay. But for time, let me go to Uncle Ben. Uncle Ben, the Secretary of State for Home Department has a right to vary the conditions. Is that right?
Well, that's right. And I think at the beginning, we explained that under Section 3 of the 1971 Immigration Act, the Secretary of State has discretion to put conditions on people's residence. That discretion includes a condition of no recourse to public funds. And therefore, the courts have held. In this case, the Home Office conceded there's an OPI, Operational Policy Instruction, which says that now, since October this year, the Secretary of State must, if somebody applies for condition to be removed, consider it, and if the person qualifies, remove it. So it's no longer restricted to family cases and people of Hong Kong who have come to the UK. It covers almost all areas of immigration, including students, care workers, skilled migrants, ministers of religion, youth workers, every person who is here who comes under 71 Act. Almost everyone who hasn't got British citizenship or right of abode comes under the 71 Act. And in that case, because this person, I think she qualifies, because she has no work, she has no income, and she's got a child, she will qualify for the no recourse to be removed. And this case in law, we say, is on all fours with the case of Ahmed. Sorry, the case of PA versus the Secretary of State, where the Secretary of State conceded last minute. I can imagine the sort of cost that the Secretary of State is going to pay to the charity for wasting everybody's time and taking this case through the court system.
So answer is number two, and as Uncle Ben has explained, Section 31CII of the 1971 Immigration Act provides the Secretary of State with the power to exercise discretion in considering whether to vary the conditions of any leave granted, including the lifting of the no recourse to public funds for permission granted on all immigration routes. And he's mentioned the case. And we're so proud as BWF Solicitors family to have had a hand in this. And definitely the things that are coming up will excite you and will be of benefit to the community. And with that, I come back to Uncle Ben for us to do our traditional rounding up of the topic we have had this afternoon. Uncle Ben, over to you.
Yes, so, this afternoon we looked at how to run a successful sponsor license business, be it in the care industry or whatever industry. And now some of our people in the community are waiting to get a decision in the construction and the carpentry industry, and that should be coming online pretty soon. The first thing to remember is the 5 thematic areas. Number 1, record keeping. 2, reporting duty. 3, complying with immigration rules. 4, complying with wider UK laws. 5, not doing anything or behaving in any way which is inimical to public policy. If I take the 1, which is your reporting duty, you have a duty to report if somebody fails to work, fails to listen to your instructions, their course is cancelled, don't report. You have to report this within 10 working days, sometimes 20 working days. 2, record keeping. You are mandated to keep all records in one of 2 formats, either a paper record or electronic. Electronic can be a PDF, a JPEG, or a PNG. Any of them will be acceptable. Anything that you can keep in a portable format, you'll be able to keep. Included in your record keeping is the pay slips that you have given to these people. They must all be kept throughout the time that this person is with you and up to 1 year after this person has left your employment, including 1 year after you've had a compliance visit. The third one is complying with the immigration rules. You don't employ legal immigrants. You make sure you document how you employ people, including documenting even those that you have given the right to work. You have to make sure that once they've got their card, you go online and check with the right to work, with a code that they've given you, the share code. You file it and put it on a record. The other one, which is number 4, is complying with the UK-wide laws, including employment laws. When they're due for maternity, you need to let them go. When they're due for sickness, you need to let them go. If you need to do reasonable adjustments because of their disability, you need to do it. Just remember that care requires lifting. If somebody's got a lower back problem, like some of us do, then clearly it means that they cannot do the work that you have to do. And clearly this is not a case of reasonable adjustment because office work is not covered under the skilled migrant for this specific route, or you recruited them to come and work as carers. The final one is a catch-all phrase. I'm afraid it includes behaving badly, not doing the right thing, not following the law, even being a domestic abuser, somebody with a criminal record, somebody with a fraud or money laundering investigations. It covers all sorts of areas. Your behavior must be above criticism. And unfortunately, once you've subjected your business to this particular regime, we always advise you to have a third party supporting you with your back office role. You are a very shrewd business person. You've run this business for a while. What you've never run before is the additional responsibilities that you've added to your work. And I'll say that if you need help, BWF Solicitors is always willing and available to support you, and we can talk after this and provide you with the necessary support that you need. But your resource center is our website, www.bwfsolicitors.com. I go through a lot of care, patience, and time to create things for what we think the community will need. When you go on our portal, there are articles going back to so many years. It covers almost all areas of the things that we talk about. I've just done an article specifically for employers, which will be published maybe next week. I've done 2 videos, usually do videos in English and in Cree, so that we can satisfy the community, including the Black community. That's why we do the English program today. But above all, you've got our numbers. If you want to call us, send us a text message or a WhatsApp message. If you are not busy, we will respond. We are your servant. We serve the community. That is why our logo, although it shows majesty, Greek pillars, Roman pillars, the traditional Ghanaian stool, the stool is upside down, which is that we're serving you instead of lording over you. Thank you very much and hope to see you next week.
Well, I think Uncle Ben has asked one or answered one of the questions I'm going to pose during Christmas. So, take note of that. But I want to invite you to come and join us again, same time next week on the program, The Community and the Law. And that's where we have the platform for the community to meet and have a discussion as to all the things legal here in the UK and outside of the UK as well. I'm inviting you, especially you, to join at the same time next week. On behalf of the production crew, Professor Ade, my studio producer, Sheila Ankra, Padma Dudu, and the staff of BWF Solicitors, wonderful family. When you come in here, you will love it. And I keep saying that it's the only law firm that when you go in there, you can have Ghanaian chocolate and some drinks as well. So come visit us, 214-2218 Tottenham High Road, Seven Sisters, on the 4th floor of the other house. Call us on 0208 493 7340 or 077 127 61884. The Community and the Law returns same time next week. Good evening.